long read one over.
Okay. Thank you, Beck, for the introduction. I know a lot of you, but I'm not sure everybody knows exactly what I do. And that's okay, because, my mom knows exactly what I do. As Beck said, I'm a lawyer and a librarian. I like to call it lawbrarian. I didn't come up with that, but I think it's good, so I'm going to go with that. At the bottom, you'll notice there's a disclaimer there that this is not legal advice. Anything I say, you can't hold against me in a court of law, I told you it's not legal advice. Okay, all right, just making sure everybody's paying attention. Go around. There we go. All right, so here's what I wanted to talk about in looking at conflict. Things that I deal with every day basically are people who want to use somebody else's material, or they want to stop somebody from using their material, or they want to figure out how they can protect the things that they create. So when I was thinking about conflict, I thought about how creators versus users, the copyright realm kind of has created this opposing or oppositional kind of feeling among people who create things and people who want to use things. And it really what didn't start out that way. And so I wanted to give a little bit of a background on that, and then talk about the rights that creators have, the rights that users have, because they do have rights, in the United States anyway. And then some suggested solutions. And I should point out that this presentation normally takes an hour, and I'm condensing it down to like 10 minutes. So there are some things I'm bringing out. So if you want to ask questions about things that you know about, or you heard me talk about, or whatever, feel free to ask about that, even if I don't cover it. But just so you know, it's very, very good. So, like I was saying, this whole kind of adversarial role of users versus creators is not something that was really intended with copyright. So copyright was created to let creators, people, authors, songwriters, etc., who create things, be able to exploit those materials, whatever they are, for a short amount of time, and then it becomes available to everybody and whoever wants to use it and do whatever they want to do with it without getting permission. So actually before 1710, before the Statute of Anne was put into law, there was actually like rumblings around, in Europe, where a lot of these things were happening, where people were saying, well, we have to have something that protects creators. They have to be able to make money and to be able to do something with whatever creative works they have before anybody else can copy it and do something else with it. So the idea was, okay, you get 14 years, you could renew it for another 14 years, and then after that period, it's open, it's available, anybody can use it, anybody can make use of whatever you create. And that idea was that there was going to be a spur in creativity. So if you make something and it's a poem or something and you never made it into a song, 28 years after you made it, I can make it into a song. And I don't have to come and get permission from you, I don't have to pay you, I can just do that. And so that's something that where the idea was, okay, then that would make more creativity, more interesting art, more things for us to appreciate in society. But then things got a little bit complicated because, of course, creators wanted to have a little more time, and then a little more time, and then a little more time. And finally, we get to the Berne Convention in 1886, where copyright term becomes the life of the author plus 50 years. So at that time, 1886, people weren't living quite that long, so maybe it wasn't that long, I don't know. But now, if you think about the life of somebody, their whole life, plus 50 years before anybody can use whatever they created, it's kind of a long time. And then I have there the Rome Act, which was something on moral rights, which is actually not recognized in the United States fully for arts, but it's really something that has to do with making modifications to work. And this was something that artists were particularly concerned about, where if they paint something, even if they sell it to you, you can't draw a mustache on it. So that has something to do with moral rights there. In the United States, you can see that the copyright and inventors and patents and that sort of thing were something that was important to the United States as well. And they recognize that the opportunity between people who are creating things and users as a way to revitalize and to explore the ways that creativity happens. So again, as I was saying with the Statute of Anne and the Berne Convention, it was that the creator would have a limited amount of time to exploit their work, and then it would be open and a part of the public domain. So you can see here that it was in our the US Constitution has language about protecting creators and inventors of creative works. So, and again, this is supposed to be for a limited time. Now, in the United States, the time that a person has to exploit their copyright is life of the author plus 70 years. So it's even longer than what's put into the Berne Convention, and actually a number of other countries have life plus 70. Many do the life plus 50, but a good number do plus 70 also. So creators have, in the United States, have these rights in whatever works that they create. They have the right to reproduce, so that means they can make copies of whatever they make and give it to whoever they want. Make derivative works. The example I gave before was if someone wrote a poem and then they decided they wanted to turn that poem into a play or a song or a book, they can do that. If they wanted to make copies and sell them on the street, they can do that. If they wanted to put it out anywhere, they can do that. Perform it. So I write a play and I authorize other people to perform it, or I perform it myself. In order to do any of those things that are listed there, you have to get permission from the rights holder, because these are the rights that they have in whatever they create. These are the things that can be protected. Original works of authorship fixed in a tangible form. So if just me talking here, that isn't something that can be copyrighted. But the fact that it's being filmed, that can be copyrighted. The actual presentation itself can be copyrighted. But me just speaking, I can't copyright that. So things that cannot be protected are things that are already in the public domain. In the United States, for things that were published before 1923, those things are in the public domain for the most part. There are some exceptions. And then anything that's not in a tangible form, ideas. So the idea of boy meets girl, boy falls in love with girl, that's an idea. If you actually write that story out into prose, that is something that can be protected. But just the idea of that storyline, the love story, you can't have protection for that. Facts can't be protected, so 1 + 1 = 2. I can't protect that. And then anything that's created by U.S. government employees working in the scope of their employment. So an example would be someone who works at the State Department and they're writing a country profile on Iraq or Somalia or whatever. Those things are not protected by copyright. But if that same person wrote a mystery novel, that would be protected by copyright, because that's not something they're doing in the scope of their employment. So users have rights too. In the United States, users have the ability to do a number of different things under U.S. copyright law. Because the idea is that, to get back to what I was talking about before, that there is an idea of balance. That, copying is good for research, and, that you guys are working in. And also that, people are creating things and they're also consuming things. They're also consuming and creating. So there's a back and forth and there's a balance to it. And so that's the idea behind, again, what U.S. copyright is meant for. So there are some limitations that U.S. copyright law puts on the rights of creators. So in copyright law, you can see in section 107, 108, 109, 110 are limitations that are on the rights of creators. So with these exceptions, you are able to do things where you would normally have to get permission, but because of the activities that you're carrying out that are allowable under these sections, you don't have to get permission. So fair use, probably a lot of you have heard about, but it's a four-part analysis where you would go through and determine based on the things that the material that you're using, how you're using it, the amount that you're using it, and whether or not there's an effect on the market. And that's something that's in the law. There isn't a specific number that's involved with that. You can, go through those steps and figure out if what you're doing falls under fair use or not. For libraries, which is an important thing for me and for you also, it's the opportunity that you have to be able to make copies for research, for personal studies. So when you're doing research and there's something that's in copyright, you can go and make copies of that thing without going to get permission from the rights holder. And that's something you can do without anybody saying anything. the first sale doctrine is actually what allows libraries to operate, because we're able to buy something and there's a sale that happens and then we can loan that material out. And that's something that's allowed under the first sale doctrine. And then for you all that teach, classroom display and performance. So something that I'm showing you in a face-to-face teaching, and it's also been extended to electronic learning and distance learning, is if I'm showing you something as a part of the educational setting, I don't have to get permission, I don't have to do anything extra, I can do that. So, I mean, it does seem like, and I know I've kind of portrayed it, that there's like a lot of tension and things between users and creators, but I think that with the way technology is moving, this is going to just continue to be on, because copyright can't keep up with the way technology moves. The way that people are able to copy changes and it grows every day. So people are able to continue to copy, but copyright law is still kind of staying the same. And so there's always going to be, I think, some kind of tension, some kind of problem between creators and users. But there are factions that are trying to kind of get around some of these tensions and issues. And I wanted to talk about one of them, which is Creative Commons. Creative Commons is a website, creativecommons.org, where you can go, if users can go and find things that are being put up and being put together by creators. So they want people to be able to use these things that they put up, which you can find music, you can find images, you can find some text, different things that people want folks to be able to use, and they want them to be able to use it for free. And so I think this is a way that users and creators are kind of coming together, because these people are making it available, they want people to use it for free, and then users can find things that they can use. So these are the licenses that are available through Creative Commons, and the highest one is the least restrictive, the one at the bottom is the most restrictive. And so the thing with Creative Commons and why I like it and why a lot of people like it is I make it available. I can say how I want to limit it. I can not limit it at all, how you use it, or I can limit it a lot. But I'm making it available, and you can use it, subject to whatever terms I set. I want to plug the Copyright Resources Center. If you go to go.osu.edu/copyright, you'll see this lovely page. And I'm done. Questions?
Like I said, useful arts on that one page. What are, I guess, not useful arts?
So making clothing. I mean, that is wait, I'm sorry, you said useful arts. That's useful art. A not useful art, I don't know what that would be.
Pickpocketing, maybe? I don't know.
Robbing? I don't see how that would be intellectual property, but
Right.
no, I don't know what the actual meaning behind that phrase is.
I wonder if that was just a dig on, some parent wrote that because their kid wanted to be a painter.
Like, no, useful. Yeah, probably.
Useful arts is patent and not copyright, isn't it?
Yes.
Yeah.
Yeah.
So
yes. Yeah.
so you can copyright anything creative. In order to patent something, it has to be good for something. So I could invent I could wave my hands around a bunch and announce I was going to patent that, but unless I could say this is a method of waving your hands around to achieve something, I can't patent it.
Got it.
Thank you, Sam. I think that's all.
Oh, who maintains the Creative Commons website?
It's actually a not-for-profit organization called Creative Commons.
There's an organization, because one of the things that I've always found very interesting about the history of copyright is the way it divides up and categorizes kinds of labor. It values one kind and sort of devalues the other. You come up with, you're a creator and you've created an idea and you've created a work. We're going to stick with examples of printed books, right? But this is a great way to give profit to the person who came up with the idea of Hamlet, and yet not really recognize the labor of the person who actually made Hamlet appear, and either materially through acting, providing the place for the show to happen, or in cases of books and other kinds of print, just for one example, but we could extend it to the digital age too, right? the work of the person who actually makes your poem appear in print on paper with an illustration with ink and binding and all the work that goes into that. Okay? The person or the persons who do that are not covered by any kind of.
Right, but so something that got cut is that, the idea of a work for hire. So they're being paid, they're being compensated for the work that they're contributing to it. So, and if I go to somebody, I'm writing a children's book about whatever, and I need somebody to do illustrations, that person would not be doing those illustrations if I weren't paying them to do it for me.
Right.
So that a work for hire means that they're being compensated, so.
I'm not saying that it's unjust the way we're compensating for labor. I think it's an interesting observation in the history of copyright law, the way that labor is divided and redefined, especially when it comes to for example, the making of books, right? In a time when an author actually was in the print house involved in the actual physical production of a book. This was a great way to sort of separate that, and then we come up with this idea of the author as a person who works in the workshop of ideas, right? And we place a value on that kind of, and that's why they're called creators, not laborers or artisans, right? But then we have all the other people who maintain a nonprofit organization that keeps the website running, and the editors that make the magazines come out and look good. And I'm wondering if in the future those two things are coming back together again. People who are making music and making plays are also in their homes with their laptops and the machines that they need to actually produce it too.
Other questions?
Let me see if I can form this question. So you mentioned the first sale doctrine, which presumably allows you to sell. It says once you've used a book, you're allowed to sell it to someone else.
Right.
I'm wondering if you have digital media. I suppose there are all kinds of rights that we sign away when we buy something or something. Is that true? Or?
So digital media and like books and music, that's like the next thing that's being litigated. But so far, part of the thing is like what you're getting to is that when you are signing up for those things, you sign a contract that says, this can be taken away at any time, you won't redistribute it. And if you sign a contract that says that you will not do that, you cannot do that. And so most of those things are governed by contract. Although there is a company that's trying to make the claim that they can help people to resell music. So resell the MP3s that you find, and they're saying that they'll wipe it from your hard drive so you no longer own it. But I mean, the thing is, these things are copies of copies. So they may wipe it from your hard drive that you are linked into on the internet, but you maybe have it already on something else. So it's something that's being disputed now in court, actually. But it was recently dismissed, but there's a thought that the people who have created this service are going to appeal that. So we'll see what happens.
In an ideal world, if you could reinvent copyright law right now for the digital age, what would it look like?
Oh, it would be a mess, but like everything at the library would be awesome. So the one thing that if I were able to try to deal with would be, and you guys will recognize this, is that with academics, you own your copyright. It's the one kind of it's not an official exception, but there's a tradition with universities where you guys don't operate under a normal work for hire structure. So normally, if you create something to do your job, that is work for hire. But in academia, you own your own copyright. So you can do whatever you want with it. In my ideal world, academics would read contracts that they're signing, where they're signing away their copyright to publishers, and make sure and understand what rights they're signing away, and actually instead negotiate for some rights to retain something. Because in what's going on now, and it has been going on for a really long time, is when you sign away your copyright, you're signing away a lot of things. Like you're signing away your ability to be able to, in a lot of time, in a lot of instances, you're signing away your ability to even be able to cite yourself. to use one of your own charts that you created. A lot of times that's what people are doing. And most of the time they don't know that because they're not reading the contracts that say this. And if you do read it, I mean, you can still try to make an attempt to negotiate. If I were in a perfect world, like there would be, I have no problem with academics keeping their copyright, but I have a problem with people signing away their rights and not knowing it. And so in an ideal world, academics would read their contracts and actually, maybe try to negotiate for keeping rights and retaining some rights and making sure that they're able to do many of the things that they want to do later with papers that they write. So, yeah.
How do you feel about the NIH directive that all of the research they fund it doesn't have to be in the public domain, but it does have to be freely accessible?
I think it's great. I mean, I think what Sam is talking about is a number of, actually they're trying to extend it to a number of other federal agencies. When they fund research, that research should be put into, or they're trying to direct that research be put into an essentially open access repository. So here at OSU, that repository would be the knowledge bank. And so I think it's great because, to me, it doesn't make any sense where if the federal government with your tax dollars is funding something and then it goes into an Elsevier journal or Elsevier whatever and you can't access it. Like, how does that make any sense? So I'm all for it. But of course I would be.
So when you take Copyright 101, what are the main examples they give you of copyright? What are the most famous copyrights that exist out there? Is there something that they give you as the first example of a copyright?
Probably the first thing that people will talk about is the Gutenberg Bible. So that was the first successfully printed thing that came out. So when people really do a historical, this is books and something that someone created and put together and made available to people, that's the first thing that people talk about, and that was 15 something. That might be wrong on the dates, but that's the first thing that people kind of talk about. One thing that I did mention, like I said, I was trying to save time, but in the United States, copyright is automatic. So there's nothing special that you need to do. If you want to file to have a copyright, you can do that, but you don't have to do anything. As long as it's fixed in the medium, you have copyright protection automatically.
Does that mean even through digital media?
It goes, it's electronic, all of that, yeah. So as long as you fix it in a form, you have copyright protection. Now, if you have to do litigation or you need to bring a claim against somebody, it helps if you have registered it because that gives you a date of registration.
What's the rationale for the length of copyright being age of the creator plus 70 years? Or life of the creator plus 70 years? It seems like an extraordinarily long period of time to protect some work.
People believe that they will make money for a really, really long time on things that they created a really long time ago.
2 generations.
Yeah. So other people would say that certain companies have encouraged that length of time, and probably more creative companies have concerns about copyright and being able to hold on to copyright for a really, really long time.
But you say this dates back to the early 1900s when the average life expectancy was in the 50s, not 70s.
Right.
So that's greater than 2 generations.
So
that's interesting.
that's not users pushing that. That would be creators that would be pushing longer and longer times. So the first time I had up there, it was 14 years.
Right.
And then the next iteration was 14 years and renewed for 14 years. And the next time was 28 years, then renewed for 28 years. And then they just kept going up and up and up and up and up. And the rationale for life plus 50, life plus 70, I really have no idea. I just think that they wanted it to be a long time. And the reason this thing with this life plus is that, a lot of times, you don't know who made something. And so it creates this kind of quasi-status thing where it's still in copyright, but you don't know who to actually talk to because the creator's dead, can't get in touch with the estate. So it's like this whole empty space of things that people want to use, but they can't figure out who to talk to use it.
one more quick question to this one and then we'll break.
What if a company owns the copyright?
So,
Like how long can they?
Yeah, so copyright for corporations, let's see if I get this right, is from the date of creation, 95 years, or 120 years. I'm gonna get this wrong. So it's either 95 or 120 years. And the determining factor is like date of creation, but essentially like you won't be alive when it's available for people to be able to use it. It's if it was made by a corporation. So the example of that is Mickey Mouse. And most people, I think most people were like following copyright issues, like with the Sonny Bono Act. That's where that extension, the corporate extension, came about. Is because Mickey Mouse was going to go into the public domain, and so Disney, being the very small family company that it is, came up and made sure that was not ever going to happen. So.
Well, that is time for this.
Thank you.
So if we break for like, it'd be great if we could keep it to like 3 minutes, but try and be back in